Okay, I think that we can start. Welcome everyone, good morning. So my name is Luisa and I will host this very interesting webinar today, which is part of the Young AIPPI Member Summit. And so you are currently looking at the satellite session for EMEA. So today we have some very diverse and very interesting talks by great speakers prepared. So the session will be roughly 90 minutes. And we will have, as I said, 3 speakers that all discuss very different topics, very current topics though. And so because the topics are quite independent from each other, we plan to, for each topic, hear an approximately 20 minutes talk by the respective speaker, and then have about roughly 10 minutes for questions and a short discussion before then the next speaker starts. So the speakers for today, which I will then also introduce to you in a bit more detail before they start to speak, are Vanessa Halle from Cameroon. We have Pierre Trousson from France and Tilman Künzel from Switzerland. As I said, my name is Luisa Galbraith. I'm an attorney at law at MLL Legal in Switzerland as well. So next, before I introduce you to our first speaker in detail, I will briefly present the housekeeping rules for this session. So if we could have the housekeeping slide, great, thank you. So for the information of all of you, this webinar will be recorded. If you have any questions to the speakers, please submit them via the Q&A box, which is circled in blue on the slide. So as I said, the Q&A session will be at the end of every presentation because they are very diverse and it does not make sense to have a common Q&A session. And if you have any technical problems or questions, please send a message in the chat box, which is different from the Q&A box. It is circled in yellow. And at the end, there will be a brief survey. And we already thank you very much for your feedback. So now I would like to introduce you to our first speaker. So if Vanessa could start sharing her slides, that would be great while I introduce you. So, well, the first talk will be held by Vanessa Halle. Vanessa is a partner at Nico Halle & Co. law firm in Douala in Cameroon. She there leads the intellectual property practice. Also, Vanessa is dual qualified. She has been called to the Bar of England and Wales in 2011 and the Cameroon Bar in 2013. Furthermore, she's also an accredited IP attorney at the African Intellectual Property Organization, and she regularly advises clients across diverse industries on things like IP portfolio management, brand strategy, also litigation, transactional matters, including franchising and licensing. Her expertise also spans a wide range of IP rights, including patents, trademarks, copyrights, and also geographical indications. Vanessa is an active contributor to the global IP community through her roles in INTA, FICPI, AIPPI, PTMG, and other professional associations. So today, the topic of Vanessa's presentation is IP protection in the African Intellectual Property Organization. And yeah, Vanessa, the floor is yours. Thank you very much for your presentation.
Thank you very much, Luisa, and thank you everyone for joining our session this morning. So today we will be kicking off the EMEA satellite session with IP protection in the OAPI jurisdiction. And I think that this is a very key jurisdiction because out of the 54 African countries, the jurisdiction actually covers 17 of them. So it's actually a very, very interesting jurisdiction that I think that AIPPI, the young members thought that, you know, this will be great for everyone to know more about what the organization is about. So just briefly, we will be just tackling what the organization is, the type of rights that it protects, and patents and trademarks. I particularly chose these two because from my experience, these are the IP rights that are majorly protected by international clients who come into. We have a few geographical indications, but when you do the comparison in terms of trademarks and patents, the percentage is quite low. Same with utility models and industrial designs as well. We'll also touch on dispute resolution because everyone wants to know, when I protect my rights in OAPI, what are the options that I have? What's the legal recourse I have? If there is any infringer or someone who is taking advantage of the exclusive rights that my protection has granted me. And lastly, there is a not to be confused with, and when we get to that point, we're going to deal with that. So the African Intellectual Property Organization is actually it's a regional organization comprised of primarily Central and West African countries, primarily French speaking. That is set up for the protection of intellectual property rights. We've got 17 member states currently. We have Benin, Burkina Faso, Cameroon, the Central African Republic, Chad, Comoros, which is the last country that actually joined OAPI. We have Congo, Cote d'Ivoire, the three Guineas, that's Equatorial Guinea, Guinea-Conakry, and Guinea-Bissau. We have Mali, Mauritania, Niger, Senegal, and Togo. And the official languages are English and French, which means that any documents that are submitted at the registry in support of any application, be they patents, be they trademarks, be they your detailed description, be they your priority document or your power of attorney, they have to be in English or French. So if you're coming in with a French priority, for example, there's no need to translate it into English. And if you're coming in with an English priority or you're coming in with regulations of use from claiming priority of for a mark that was filed in English, you don't have to translate it into French. So it's a bit in French they say un peu polyvalent. It's a little bit bilingual. And the currency that is used for payment of official fees is the franc CFA. The governing regulations are the Bangui Agreement, which was lastly revised in 2015. Now, even though it was revised in 2015, the different annexes actually came into force at different times. So, for example, on the 1st of January 2025, that is when the annex on patents and utility models came into force. Whereas in 2020, the annexes on trademarks, industrial designs, geographical indications, and a few others actually came into force from then. So even though it was revised and adopted in 2015, different annexes came into force at different times of the year. So OAPI is a member of several international conventions. I just picked this up. We have the Hague, which the Geneva Act of the Hague Agreement, which is what is used for industrial designs here. We also have new varieties of plants. And recently we had the Madrid Protocol, which is the instrument that enables OAPI to be designated in international applications. So right now, previously, if you wanted to file your trademark in OAPI, you had to come through an agent in OAPI. But now with the Madrid Protocol, if you're doing your filing internationally, that's via Madrid, you can actually designate OAPI as one of the countries. And it's not possible to designate an individual member state like Cameroon or Togo or Benin. If you're designating OAPI, it's covering all the 17 countries. And we have the Singapore Treaty of Laws of Trademarks, which was applicable since February 2016, the Geneva Act of the Lisbon Agreement on the appellations of origin, March 15, 2023, and the Budapest Treaty as well, since March 15. Now, what are some of the advantages of the OAPI filing system? As already indicated, we have just two languages, as opposed to if you were maybe filing in a country that if you're filing out, okay, for example, you have 17 countries and not all of them, some of them have different languages. Instead of filing in another language, let's say Chinese or Arabic or Mandarin or Russian or Hungarian, for example, you would have to maybe incur translation costs that will be incurred, and you will have to also deal with different attorneys in those different jurisdictions. So one of the advantages that using the OAPI filing system is that you're using just those two languages, and also there's the cost efficiency part, because we all know that I mean, we are all IP attorneys, we all understand the costs that are racked up when you are dealing with IP filings in different jurisdictions. So if you had to do 17 different countries, for example, the costs will be significantly higher than going through OAPI, which covers all 17. Now, a very key feature about OAPI is that when a country joins that organization, it waives its rights to national filings. So currently, it's not possible to file nationally in Cameroon, nor is it possible to file in, let's say, Benin or Togo or Senegal. And also, it's not possible to designate any of these countries, like what happens with the Madrid, where you can file and then you designate individual countries, or what happens with ARIPO, when you can do via ARIPO and then you designate individual countries. What happens is there's a regional uniformity. There's a harmonization of IP laws, and that streamlines the process and the procedures across all 17 member states. The registry is based here in Cameroon. So once a member joins OAPI, it doesn't have any national registry. So it's not possible to go to Togo and say, I want to file my trademark in Togo, because Togo doesn't have a national registry. They would have a liaison office, which is basically, if you're in Togo and you want to file your IP rights from Togo, it's like a deposit office where you go and you deposit your applications, and then the liaison office transmits it to the registry. So we don't have individual certificates issuing from different countries. You have one application date, one filing date, one renewal date, which covers all the 17 countries. So it pretty much streamlines the process and makes it easier to manage, especially in terms of costs and deadlines and documentary requirements as well. So what type of IP rights are protected? Under the revised Bangui Agreement, as I said earlier, it's very harmonized. We have our Bangui Agreement that has 10 annexes, and each of these annexes deal with the different types of IP rights. We have Annex 1 on patents and Annex 2 on utility models, which came into force on the 1st of January 2025. Then we have Annex 3 on trademarks. We have 4 on industrial designs, 5 on commercial names, 6 on geographical indications, 7 on literary and artistic property, 8 on protection against unfair competition. Annex 9 deals with layout designs of integrated circuits, and Annex 10 deals with plant varieties. So basically, if you're looking to register any of these kinds of IP rights at OAPI, these are the various annexes that are going to govern your application, and they are also going to give you for example, what will consist of a valid patent, what consists of a valid trademark, how do you go about your position, and things like that. However, with regard to Annex 7, which is literary and artistic property, even though we have an annex on it, the actual application or the registration of copyrights doesn't take place at the OAPI registry. OAPI has granted the member states, the authority to set up the necessary platforms for the protection of such kinds of IP rights. For example, you have plastic works, you have the ones who deal with music, who deal with literary works, who deal with paintings. Those are different platforms that are set up by each member state. But however, they have laws. For example, in Cameroon, we have a national law on protection of copyright, but really it's in line with the Bangui Agreement. It, however, goes on to talk about the implementation or how to go about the process of enforcement of your copyrights on the Cameroon territory. So we, as I said earlier, we have patents in OAPI that had a recent overhaul. Previously, it was, in terms of costing, it was, I think it was less costly than what the patents right now are. Um, well, we'll start with the examination. Previously, we didn't have substantive examination, but with the new um, provisions of the 2015 and next, we now have substantive examinations. We have OAPI has been ramping up their capacities in terms of having the examiners that will actually do that. They've been carrying out trainings in Cote d'Ivoire and to ensure that in terms of substantive examination, it's properly done. And it's expected that they will rely on the international search report and international international preliminary examination report when conducting substantive examination. So previously, when we were filing applications for patent in OAPI, we didn't have to provide the international search report or the international preliminary examination report. But now when we're doing our filings, we have to also submit these documents because it acts like a guide and it aids the examiners in their examination. And then also it's possible to file voluntary divisional applications at any time before grant or in response to an office action pursuant to the examination. And also, it's now possible to oppose patents and utility models. This is a novelty. We didn't have this before, but now it's possible to oppose them. The opposition, like basically the applications are published as well. And within 3 months, any interested party has a right to oppose them. So either you file an opposition or a claim of ownership, and then you have to motivate your reasons for requesting that the application be rejected at the or be rejected and not registered. Further, we also have non-PCT applications that will be published within 18 months of the filing date or the priority date, and all our patents will be published upon grant. So previously, there are fees now for different bands. Previously, we used to have the main fees were the registration fees, the publication fee, which was just a single publication fee. We used to have the priority fee. We used to have the claim fee, length of different, a length of detailed description, then the annuities as well. But with the overhaul, we have fees for the examination of the application. We also have a fee for the publication of the application, after which any interested party can file the opposition. Now, if an opposition is not filed or where you're able to overcome the opposition, there is also publication of the registration, and that publication also entails a cost. And then there is now the registration fee. And then we also have the annuity fees that have also increased. I think the fee schedule, the updated fee schedule, is found on the OAPI website. So, I mean, in terms of, you can do a comparison of what was and what is, or you can just go with what is right now. And also, we also had the issue of annuities. Annuities that are due in 2025 but were paid in 2024 will be subject to the new annuity fees. For some firms who during filing they preempted the 2025 annuity fee and paid them in 2024. But because they are due in 2025, the registry deems that okay, the balance has to be paid. And then obviously they're going to notify the agents as well. So that's one thing to look at. If you have any patents that were instructed for filing in the region and annuities due in 2025 were paid in 2024, that's something that for the protection of the client's interest or the right holder's interest, you could want to look into. Now we're moving to trademarks. And with regard to trademarks, the filing routes, we have regionally, and I put that via the registry, or through the national liaison. It's important to note that when you file through the national liaison, the date at which you submit at the national liaison is the date that is the application date. It's not the date where it reaches the registry. So the records are pretty much streamlined on that. Or, as I said before, you can do that through the Madrid. The online filing process also witnessed a change, I think about 3 years back, where now we have online filing. Online filing for trademark registrations is something that commenced last year. Previously, we were still using the paper filing system, but now it's possible to do your online filings. Previously, the official filing receipts were issued within 2 to 3 months, but now within 14 to 21 working days, you can get your official filing receipt with your application number. Now we also have publication of the application for opposition purposes. Prior to the registration, before the new provisions came into force, there was no publication of the application and oppositions were done post-registration. So now we have two publications. The first is the publication of the application for opposition. And if there is no opposition or you overcome the opposition and you're successful, the trademark is registered and is published. So we now have two we now have two publications in for trademark processes. And now we have formal examination, which we've always had. We check if the fees are filed, required documents, priority or regulations of use, jointly owned, certification, marks, etc. In terms of substantive examination, previously, it wasn't as stringent as it is right now, but I think that the registry is a lot more stringent in terms of the substantive examinations. We've had cases where the marks were rejected because they were not distinctive. Previously, that really wasn't the case. So when the examiner is reviewing the substantive, they'll check if it's devoid of any distinctive character. They'll check if it's contrary to public policy, accepted principles of morality of the law. They're also going to check if it reproduces or imitates any coat of arms, flags of countries, or any abbreviation or acronym of an intergovernmental organization. They will also check if it reproduces or contains among its elements an international non-proprietary name. Recently, we learned of the trademark which was applied aspirin, which was actually rejected because aspirin is an international non-proprietary name, so the registry rejected that. And it reproduces, imitates, or contains amongst its element a geographical indication. And then they will also examine whether the regulations of use are contrary to public policy and morality. So those are some of the things that the examiner reviews in their substantive examination. Now, if you've registered your trademark or your patent and you're trying to enforce same against any infringers or counterfeiters, what are the various options that you have? We have the administrative route, which is sometimes we deem it as the easiest one because the deadlines are pretty firm. For example, if you're doing a claim of ownership or an opposition, you have to file it within 3 months. And then, with a claim of ownership or an opposition, we are looking at a year and a half maximum. Sometimes it's like a year to get your decision. So it's deemed the faster version of dispute resolution than going through the courts. So you start with the administrative level where you do your opposition or your claim of ownership. If you get a decision that's not in your favor or the other side is not happy with your decision, they can appeal. And they will appeal that decision at the Higher Commission of Appeal. And this appeal must be filed within 60 days at the High Commission of Appeal. And when the High Commission of Appeal gives that decision, there's no further recourse because it's not possible to appeal the decision of the High Commission of Appeal. Now, if you are not able to use this route for opposition, maybe you missed the deadline, but you're still in position to bring an action in court. then you have to look at the national courts of the member states. You can bring your infringement actions. It could be a cancellation action based on non-use. It could be an invalidity action. It could be an action on unfair competition, etc. And all of these are going to take the process of a normal court process. You're going to have written submissions, you're going to have oral hearings, you're going to have adjournments. And yes, this could take a longer time due to multiple adjournments. But one very important thing to note is that when you get your decision from a member state, you have to notify the registry so that it becomes effective in all OAPI member states. So there's also the uniform applicability of decisions because OAPI is deemed as one unit, is deemed as one country. And that's why even when you're doing an action or cancellation action based on non-use, the requirement is where the mark has not been used on any OAPI member state, which means that even if you use it on just one OAPI member state, that qualifies as sufficient use. So for the people who are looking to exploit their marks only in particular countries of OAPI, they're not compelled to use the marks in all 17 countries. If you use it just in Cameroon or in Cote d'Ivoire or in Senegal, that's sufficient use. You don't have to submit any documents of actual use or potential use. And even when you're renewing, you don't need to provide any documents proving that you've used the mark as well. So that's just that. And now we've gotten to the not to be confused part. I actually thought to include this because the only difference between the names of the organizations is regional. Because when you look at the African Intellectual Property Organization, which is the French-speaking countries, we have also the African Regional Intellectual Property Organization, which is ARIPO. And ARIPO is the equivalent of OAPIs, just that it's primarily the English-speaking countries of Africa. That's the southern countries, the eastern countries, whereas OAPI is primarily the Central and West African countries. So currently, ARIPO has 22 member states. I read just this morning that Mauritius, yeah, we have Mauritius up here. That's right. They've deposited they've deposited their documents to join. So we have that there. Now, with regards to filing formalities, the difference between OAPI and ARIPO is that you can also have your national filings, or you can file in ARIPO and designate a national member. Whereas in OAPI, it's not possible to designate and it's not possible to have a national filing. So they have also their protocols. Well, so while OAPI has one agreement which has annexes on the different kinds of IP rights, ARIPO has different protocols for different IP rights. They have the Harare protocols on patents and industrial designs. They have the Banjo protocol on marks. They have the Swakopmund protocol on protection of traditional knowledge. They have the Arusha protocol for protection of new varieties of plants. They have Kampala Protocol on voluntary registration of copyright and related rights. That was done in 2021. And then they have the Lusaka Agreement on the creation of the organization, which was in 2016. So that's just a little bit of additional information that I just thought to provide, because when you add the 22 countries of ARIPO and the 17 countries of OAPI, that's 39 countries of Africa. Which is more than already half of the number of the African countries. So I just thought to include that the two shouldn't be confused. They have different filing formalities and different member states, but that it's also a regional organization in Africa as well. And that is all I have for today. And thank you for your attention and for your time. And yes, any questions? Over to you, Louisa.
Thank you very much, Vanessa. This has been very interesting and also helpful with the distinguishing of the two organizations. So I haven't seen any questions in the Q&A because I think your presentation has been very clear. which is a positive sign. Maybe just one question from my side. I thought it was really interesting what you said about enforcement and the applicability of the decisions. So just that I have understood correctly, if I file, for example, an infringement action with one of the member states, will an injunction, if I'm successful, an injunction will also be issued for the whole territory. So I don't have to go to each member state to lodge an infringement action. And you're on mute, Vanessa?
Oh,
Yeah.
sorry about that. So there are two things. If you're looking at, for example, seizures, and you're trying to seize goods in, let me take Cameroon, and let me look for another country, Cote d'Ivoire. So if you're trying to seize goods in Cote d'Ivoire and Cameroon, you are actually going to have to go to Cote d'Ivoire and have the get the injunction, get the seizure order, effect the seizure. Come to Cameroon, get the order, the seizure order, effect the seizure. However, when you proceed with that, you have 10 days within which you must bring a substantive action, because you cannot just file a seizure order and just put your hands in the air and say, I'm done. You actually need to bring an action against the person. And then and at most times, what that means is that you have to bring an action. Maybe you are requesting the other side damages, or there are so many penalties. There's imprisonment, there are fines, there are the penalties that could be paid for that. So once you go to court and you're successful, you can actually take that decision and give it to OAPI, and then it becomes a decision that was issued. A decision with regard to the cancellation of a trademark, for example, spans the entire OAPI. So if I'm doing an invalidity action and I bring it in the court in Mali, for example, and the Mali court says that, oh, they have to cancel this trademark, because the mark is cancelled in Mali, it cannot be valid in the other 17 countries because it's deemed as one jurisdiction. So I'll have to take my decision now and go to the registry, notify them, and then they're going to have to publish it. But even minus the publishing, once you have a decision, it's effective in all the 17 countries.
Okay, understood. Very interesting. So we have one more question from the audience, which is, since substantive examination was introduced in OAPI, have you experienced any backlog in issued reports, or has the office managed to keep up since the introduction?
So what I've witnessed is that the official filing receipts do come out faster, but we are not. I haven't gotten any. Well, I mean, we're only in July. I haven't gotten any certificates of patents. For the ones I filed in January, I haven't gotten any. And normally, I wouldn't have gotten them even under the previous one because it was meant to last for a while. But what we understood from the training which OAPI had with their IP agents is that they were looking at about 18 months for the entire process, 18 to about 18, 25 months for the entire process. So it's a work in progress, actually, because we are also trying to understand how the opposition system works, because for patents, it's novel. And for our qualifications, for example, here in OAPI, there are many of us who don't have science backgrounds, because when you're qualified as an IP attorney, for trademarks, patents, and designs and all the IP rights. So several of us who are IP agents here do not actually have the mechanical engineering or the biochemistry engineering. So we are also looking to see how the opposition process works out. I haven't had a case of an opposition for a patent yet, but it would be very interesting to actually go and watch the first one. Let's have the guinea pig one to see how it's decided and everything.
Mm-hmm. Yeah, that'll be very exciting. Thank you so much, Vanessa, for your presentation. I
Thank
think
you.
we're out of time, and I will go and introduce you to your next speaker. So the next presentation will be held by Pierre Trousson. I kindly ask Pierre to already start sharing so we don't lose time. So Pierre joined the French law firm JP Calcenti Associé as an associate in 2018. He there specializes in intellectual and intangible property and advises both French and also international clients on contract drafting, negotiations, and interactions with administrative authorities. He has also developed a strong litigation expertise, particularly in patent, trademark, and advertising law, also including complex multi-party disputes. He also supports clients in anti-counterfeiting efforts before civil and criminal courts, and there he can draw from his experience from working at a leading international firm in the sports equipment sector. His practice combines strategic advisory work with hands-on litigation and enforcement across diverse IP matters. And today he will talk to us about a very hot topic, I would say. So the topic is web scraping, a legal analysis of a growing digital practice. Thank you very much, Pierre, for your presentation already now, and the floor is yours.
Hi, thank you very much, Luisa, and for letting me speak, and thank you all for coming today. My name is Pierre Trisson, and today we're here to speak about web scraping, legal analysis of a growing digital practice. Well, behind this sophisticated and a bit complicated title, the idea is to discover first what is web scraping, and secondly, does it constitute a violation of IP rights? So let's start. First, we will see in our program the definition of web scraping, and then we will try to see if web scraping can constitute a violation, an infringement of copyrights, then if it can also be a violation of the database protection, more specifically a violation of fusion rights, and then we will see if it can also be an act of unfair competition or parasitism. So let's start. First, the definition of web scraping. What is web scraping commonly? And is there even a legal definition of fraud practice? But also, why are we all talking about web scraping nowadays? It's because it became a key practice for AI. Let's start on the definition of what is web scraping. Well, basically, web scraping consists in the process of extracting data from a website or a database and saving it for analysis of other users. You can have extracting all kinds of data. It can be text, it can be images, it can be video, links, metadata, etc., etc. The idea of this extraction is to compile it, to put it in your own database or in your own spreadsheet, so you can analyze the data. So that's what web scraping is about. Keep in mind that web scraping is not only for experts. You don't have to be an expert in coding or know the Python code to web scrap the web. You can simply use now a basic program available on the internet to web scrap the web. So you do not need programming skill for that. For example, I find on the internet a very basic program named Web Scrapper that you can after this presentation, download on your browser extension, and you can start web scrap on the web should you wish. So it's something which is very, very common. That's what you should keep in mind. So now, is there a legal definition? You know what is web scraping, but according to the law, what is web scraping? Well, we don't have a definition, a legal definition of web scraping. According to the EU regulation, European Union regulation, we use the EU regulation use the terms of extraction. For example, you can find in the directive, European directive, an old one regarding the legal protection of database, that extraction shall mean the permanent or temporary transfer of all or substantial part of the content of a database. So as you can see, web scraping is quite old. Already more than 20 years ago, there was a definition of extraction of data because it already exists. So we don't have a legal definition of web scraping, but we do have a definition made by very well-known institutions such as the European Trademark Office, which defines it as the process of extracting data from websites by retrieving it and analyzing their content, which is very similar to the definition that I give you just before. Or you have also a definition made by the EU Data Board that uses another term, which is the collect of information from publicly available online source, which is quite similar definition. So now you know what is web scraping and you know how the law is dealing with web scraping. But why are we talking about web scraping? It's because now this last year it's a key practice for AI. So I put you a definition of AI. It's a definition that exists in the AI Act voted by the European Parliament very recently last year. And in this definition, what is very important is the term input and output. Input is what you put in your AI system, so you have to feed him, so you have nice input. It's because you give it to your AI system a lots of data of input that you can have a good result at the output. It means that your input you will generate very relevant content because your input it's quite good and it's quite invest in terms of data. For example, if you have 1,000 and thousands pictures of cats, you put it in your AI system, this is the input. And because you have put thousands and thousands of pictures of cats, your AI system can generate a good output, a good picture of a cat, and can know what is a cat. So this is why web scraping is very important, because thanks to web scraping, you can collect a vast amount of data to build, to construct your input for your AI system. I will just give an example. There is a company named Clearview that you probably heard about, was web scrap the websites and collect billions of images of human faces, actually 20 billions of human faces. And now this company is able to identify almost every human on Earth because of this collect of information. Of course, it was not legal, but actually it still did. I just put you here some information regarding the AI Act. I won't go into the detail of the AI Act, of course, because this text is more than 100 pages, so it's quite long. It's not our topic. Just remember that in the AI Act, you have, for example, a prohibition of scraping facial images from the internet or CCTV footage to avoid the collect of your face. You also have information regarding how to obtain the authorization of right holders to collect artworks from a legal perspective. It's the opt-out mechanism. We'll speak about it later. And you also have information regarding the transparency of your input. Where do your input come from? So this will be interesting because it means that when you web scrap the web, you have to keep information from how this collect of data comes from. So be careful if you web scrapped. So now we know perfectly what is web scraping. And when we have finished these definitions, you probably think that web scraping doesn't seem something very legal, because it's something that means that you collect data belonging to someone else on the internet and extracting them and reusing it for your own purpose, for your own good and personal good. So that's something that seems a bit tricky. So let's see if it's legal or not from a copyright perspective. Well, in the European Union, the EU protection of the copyright is made with the directive InfoSoc directive. And in this directive, you have it grants to right holders the exclusive right to authorize or prohibit direct or indirect, temporary or permanent reproductions. So it means that you should, if you web scraped information and most specifically if you web scraped artworks, you should obtain authorization from the author. Well, not exactly, because you have many exceptions. So let's see now the copyright exceptions that as a web scrapper, you could claim to confirm, to validate your collection of data. The copyright exceptions, there are different kinds of exceptions, but we will focus on two of them that are relevant for web scraping. The first one is in the InfoSoc directive, it's Article 5 for temporary reproduction, and the second one is in the Digital Single Market Directive voted in 2019, the TDM exception, the text and data mining exception that you probably heard recently about. So let's focus on the InfoSoc directive first. Well, the InfoSoc directive, as the Article 5, provides a temporary an exception that authorizes you to temporarily reproduce a copyright. So you don't need the authorization of the author, of the rights holder, if you do a temporary reproduction. Well, actually, this exception is quite strict, because the reproductions has to be temporary, but also transient or incidental, and you must also, this temporary reproduction, shall not have independent or economic significance. Well, as you can see, this exception is quite strict, but it's not over. You also have to comply with the 3 steps test mentioned in this directive. So it means that your temporary reproductions must additionally apply only in certain special cases. It must also not conflict with the normal exploitation of the work, of the artwork held by the copyright holder, and it must not unreasonably prejudice the legitimate interest of the right holder. So as you can see, a quite strict exception. So let's focus on the other one, the TDM exception, that is more relevant for web scraping. So the TDM exception, you have 2 kinds. It's text and data mining exceptions coming from the Digital Single Market Directive. And in these TDM exceptions, you have 2 different TDM exceptions, a general one and a scientific research exceptions. Let's remember that you have, even in these exceptions, comply with the 3 steps test that we just speak in the previous slide. So 2 different kinds of TDM exception. Let's focus on the first one, the scientific research exception. And I put it here, the text, but I will decompose it as it will be easier to understand it. So this TDM scientific exception, it means that you are, as a scientific, authorized to extract and reproduce data from the website, from your web scraping, but only if you are a research organization or a cultural heritage institution. You also have to carry out purpose or scientific research when you do your text and data mining. So you will have to focus that when you are web scraping, you are doing it only for scientific purposes. And finally, you must have a lawful access. That's the criteria for scientific research exception. The other criteria, the other possibility that you can claim to benefit from this exception, should you wish to web scrap, is the general exception. This general exception, as you can see, I put here the text, and let's again decompose it to make it easier to understand. The particularity of this exception is that everyone can invoke it. Everyone can say, I'm in the general exception. You don't need to be non-lucrative organizations. You don't need to be an heritage institution, etc., etc. Everyone can do it. But, and it's strong criteria, you must respect the opposition made by the right holders. So the principle is that you can web scrap the right unless the rights holders has explicitly mentioned its opposition for your web scraping. It's the opt-out mechanism that you probably heard a lot about. This opt-out mechanism can be made in any way. It can be made, for example, with the use of metadata. So it means that when your robot will web scrap the web, it will see information left by other robots saying that I don't want my website to be web scrapped. Or you can also put your opposition, for example, in your terms and services conditions. So you have finally also to comply with the 3 step test that I told you about. So now you have all the exception, and I told you all these exceptions because there is a very, very recent case law issued by a German court, the Hamburg Regional Court, last September, which was dealing with the first European case law about web scraping and AI. And this case is particularly interesting and particularly relevant. The facts were the following. A claimant was photographer, and he was acting against a defendant, the company Lion, which is a non-profit organization. And Lion was offering free access to his datasets, its database, composed only with hyperlinks redirecting to picture on the internet. It means that Lion was not had not the pictures, the photography directly on his website. His website its website was only redirecting via hyperlinks to other websites with the photographer. However, this dataset, the dataset owned by Lion, was created by web scraping the web, and specifically the pictures, analyzing them, and then at the end, only deleting the picture. So the claimant has seen this picture, has seen the hyperlinks redirecting to other websites, and decided to sue Lion because he has explicitly opt out. It means that on his website, the claimant has expressively mentioned its opposition to have its website web scrapped. So in this case law is interesting because before the court, Lion has raised all the exceptions that we just talked about. So Lion has invoked the copyright exceptions. He was stating that he was reproducing, but only for temporary, So there should not be an infringement copyright of the picture owned by the client. Well, the German code said no, you can't. This extension is not relevant because the reproduction is neither transient or incidental. So as I told you before in the previous slide, this exception is quite difficult to apply. The other exception that was raised by Lion is the TDN, the general TDN exception, the text and data mining exception. Well, here the code did not really go into the detail. She simply considered that there was the argument, this exception was apparently quite relevant because the author, the claimant, has effectively opted out and mentioned its opposition. And the court did not go into the detail of this exception, the general TDN exception, because it's considered that the TDN for scientific research was more relevant. And it did validate this exception. The court considered that there were no commercial aspects for Lion when he offered its free access to its data set, to its database. And it also considered, the court also considered that the use made by Lion was for scientific purposes, scientific knowledge, because this information could be used to train AI systems. So there was a perspective of scientific research. So in this case, the claimant was dismissed from his claim. So I think it's very interesting because the first thing that you could see when you heard about web scrapping is that it does violate probably copyright law. But in this case, you can see that because of specific exceptions, while the web scrapping was validated here by the courts. So we have seen the copyright exception. Now we will see the database protection. Because when you web scrap the web, you can also maybe violate sui generis rights. So let's see what it is. I won't go in the detail of the protection of the database with this directive. You should only know that that's when you have a database, it can be protected by copyright, not its content, its format, but it can also be protected by sui generis right. So let's focus on sui generis right because the copyright is quite rare, quite rarely invoked because it's difficult to comply with this criteria. So let's focus on sui generis right, which is quite more common. So sui generis, I put you here the article, but we will again decompose it to see what it means. Well, with this sui generis right, you are the maker of the database has the right to prohibit extraction and reutilization of the whole or a substantial part of the database. So to benefit from this protection, the right holder must prove that he has made substantial investment in obtaining verification or presentation of its data. That's the criteria. Only if he managed to prove this substantial investment, then he can prohibit extraction, he can prohibit web scraping of his database. Well, but that's not over. The European Court has decided to add a new criteria based notably on the recitals in the directive. And the court said, well, the maker of the database should also prove that there is a risk in case of web scraping, there is a risk to the possibility of redeeming that investment. So the maker of the database has to prove that he has a risk to lose a lot of money because of the extraction of the data in this database. And that's changed every case because this new criteria is very, very difficult to fulfill. For example, I put you here a judgment issued by the French court, Paris courts, very recently in February. And in this case, the courts considered that there were no violation of the sui generis rights, despite more than 100 million euros invested by the maker of the database, and even in the presence of 90% of the extraction of its database, because the maker of the database did not manage to prove a risk to the possibility of redeeming that investment. So what here you should keep in mind is that the violation of that you can have a validation of web scraping, despite substantial investment and also significant extraction and reutilization of your database. Well, you also have exception of sui generis, but I will be very fast on it because the only exception you should here keep in mind that is relevant for web scraping is the TDM mining exception that we just speak about regarding the copyright exception. Well, you have the same exception for this sui generis rights. Finally, keep in mind that you have a relevant way to protect your database is to use the contractual control. Here you had Ryanair, which had a database composed mainly with data regarding the flight information. And to access to this database, you had first to accept terms and conditions. And in these terms and conditions, there was a provision, an article stating that you are not allowed to web scrape the data, you are not allowed to web scrape the website. And because of this provision, you did violate the terms and conditions, so you can be sanctioned for that. So unauthorized scrapping can constitute a breach of contract. So be careful when you write your terms and conditions. Well, that's it. We have seen the exception for the sui generis right. Now, I will just conclude my presentation with the possibility of unfair competition and parasitism. Does web scraping can constitute an act of unfair competition and parasitism? I'll be quite quick on this because there is no real harmonization at the EU level, but most of the countries do have a protection with unfair competition, but it's a bit more rare that you have a parasitism in all the country. Just in France, it's something that is very common. We must always invoke this claim, the parasitism. It means that you have to prove that you have taken undue advantage of another efforts, investment, or reputation. But this parasitism is quite more rare in other countries, such as, for example, in Germany. I just want to see that we can have application for web scraping and conclude with this conclude this presentation with this final decision issued by a court of appeal in France. Well, in this case, you have a database consisting in an index of dentist information, for example, address, phone numbers, first name and last name. So you have more than 1,000 references. And you have, in this case, the claimant did not raise any copyright right, and it did not raise any sui generis right. He just says that by web scraping his website, it does constitute a violation, an unfair competition act, and parasitism. And the court confirms and valid its argumentation. The court did consider that the reproduction of the data, the extraction of the data at minimal cost, unrelated to the scale of work or the number of entry, was indeed parasitism and unfair competition act. And the sanction was the payment of 60,000 euros. Well, that's it. I conclude here. I finished my presentation. The idea was not to make you the perfect expert of web scraping because it's a very hot topic, very moving, with lots of different exceptions. The idea is just to give you some keys of understanding so you can have a conversation with your colleagues. Thank you, everyone, for listening.
Thank you very much, Pierre. Wow, I think I've never seen someone go through so many slides so quickly and still explaining everything so well. So really interesting. Thank you so much. We have a question from an attendee, which is, would you say most companies are aware of the legal risks of web scraping, or is there still a gap in understanding?
Well, I think now everybody has heard about web scraping, but the problem is that the web is already entirely web scraped by notably the AI companies. So it's a bit already too late. All your data, the information put on the website has been web scraped, for example, by OpenAI. So it's a bit late, but it's not too late. I think you still have to use the information that I give you, notably the protection with the terms and conditions to protect your information. And for right holders, I think it's very important to really focus on the opt-out mechanism. It's quite difficult to put in place, but when you have a lot of association members of copyright protection association that can help you. So if you have a client that are authors, individuals, it's a bit difficult to put it in place, but contact your association and you will have information to proceed with it. So not too late.
So also regarding the opt-out mechanism, you also mentioned that it is possible to do it like in the metadata, which is, I think, quite an interesting option. But I mean, otherwise, as you just also said, for the individual rights owner, it's quite difficult. If you just put it on your website, like just I opt out, I mean, probably the web scraping will happen anyways, I guess. And how will you find out about the web scraping even? So
Well, the robots used for web scraping are supposed to understand what you read, what you write on your website. So in theory, they should be able to understand that you have opt out. That being said, you should try to ease the process and obtain put, for example, a mention on your website in the terms and conditions. That should be written very clearly. That would be the best way to do if you have no technical skills to put it in the metadata. An interesting fact in the Hamburg decision that I spoke about is that the courts did say that the mention into the terms and conditions, so a writing human, something writing by a human should be enough to prove the opt-out mechanism. But something that is very difficult is that you don't know the inputs of the AI system. You don't know how OpenAI is built. You don't know if it has web scraped your own data. So there are lots of discussion to give more transparency on the inputs. So you as a right holder, you should have the information that to know if the AI system is built on your copyrights.
yeah, exactly. I see that problem as well. And maybe one last question of me. So you mentioned the decision of the Hamburg Regional Court of 27 September. And so as you also mentioned, it kind of said that this is for a scientific or research purpose, although it was for training an AI system, which can undoubtedly be, I guess, a commercial purpose. Do you think that it played a role that Lion in this case was a non-profit organization?
Yes, totally. Actually, the Lion organization is a non-profit organization, and it only puts the information on the internet. But it doesn't use for its own AI system. It's another company that come to use Lion data sets for its own purpose. And you're clearly right to mention that in this case, in the German case, the court has a wide interpretation of what is scientific research, quite wide, because it said that it doesn't have to be effective as a first step. It can be scientific researchers as the future steps. And I'm not sure that in France the court will fully agree with this perspective, because we have more a very strict interpretation of scientific researchers.
Yeah, it remains very interesting. I'm excited to follow what will develop soon. And so now we're also out of time. Thank you so much for your presentation. It was really insightful. And now it's already time to introduce you to our final speaker for today, who is Tilman Künzel. Maybe you can also already share your presentation. So Tillmann is a partner at Fossius and a qualified European and Swiss patent attorney. He holds a PhD in biotechnology from the ETH in Zurich and brings experience in patent prosecution and opposition before the European Patent Office, as well as in proceedings now before the Unified Patent Court, UPC. So Tillmann regularly advises clients on freedom to operate analysis and also due diligence matters, supporting innovative businesses in navigating complex IP landscapes. His primary areas of interest within intellectual property include patent litigation and IP strategy, where he leverages his technical expertise and legal acumen to deliver practical solutions for his clients. Today, Tillmann will speak to us about litigation based on deposited material before the UPC, standards based on a recent decision. So many thanks, Tillmann. We are excited for your presentation. Please take over. The floor is yours.
Yeah, thank you, Luisa, for the kind introduction, and welcome everyone for being here today. So as Luisa mentioned, my talk will be about litigation based on deposited material before the UPC, and I will base this discussion on a recent decision from the local division in The Hague in which we were involved. So maybe as a short background for the people that do not work in the life science field, so deposited materials is a very life science specific matter. So it usually comes into play when the invention concerns biological matter that is too complex to define it just by using words. And this is stipulated in Rule 31.1 of the EPC. So it says if an invention involves the use of or concerns biological material which is not available to the public and which cannot be described in the European patent application in such a manner as to enable the invention. So this is Article 83 of the EPC. Then these conditions here have to be met, which are laid out in Rule 31.1. And the most important condition here is that then a sample of the biological material has to be deposited with a recognized depository institution. So deposited materials are usually something like cell lines, for example, that can be used to produce an antibody, or also microorganisms that can be used for all kinds of biotechnological applications. So if your invention concerns such a biological material, then you have to deposit a sample of this material with one of these institutions before you file your application. And so the patent that the case is based on that I want to talk about is such a patent where the claim is directed to biological material. So here the patent is quite old. So it was filed in 2006 already. It's directed to a brown mushroom for commercial production. So it's the brown champignon mushroom that you find in most supermarkets around Europe. And the patentee is Amicel, so it's an American company, which is the biggest commercial mushroom producer in the world. So this patent went through opposition procedure before the EPO. It was maintained in opposition based on a single claim, which is a bit unusual, but still it happens. So that one claim is directed to a hybrid Agaricus bisporus mushroom. So this is the species strain. The strain is named BR06, and then it's defined wherein a representative culture of BR06 is available from this depository institution under this accession number here. So this patent is still enforced in some European countries, so in Germany, Spain, France, Great Britain, Italy, the Netherlands, and Poland. So to give you a little bit of background to the case, so Amicel, our client, so the originator, the producer of the brown mushroom, they were already aware for some time that there is a Polish mushroom producer that is basically reproducing their mushroom strain and selling it in Poland under a different name. So they basically just copied the BR06 strain and sold it in Poland under another name. In this case, the name is Cayenne of the infringing strain. And there are infringement proceedings ongoing in Poland, or still ongoing. However, so our client did not have any hard evidence that there was also infringement taking place in the UPC territory for the longest time. So they knew that the defendant was selling the Cayenne strain in Europe, but they did not have any hard evidence because the whole market is not very transparent. So it's usually all business to business. There is not much advertisement going on. So it's mainly the producers selling directly to farmers. So it was very hard to get evidence of infringement in the UPC territory. And only then in July 2023, our client was able to obtain evidence through a bailiff in the Netherlands that Cayenne was actually sold on the Dutch market. And this was where the whole UPC case started. And so our client then wanted, of course, to stop the Polish producer as quickly as possible from selling this mushroom in the UPC territory, and therefore considered applying for a preliminary injunction at the UPC. And here, as a short background, so the requirements for obtaining a preliminary injunction at the UPC. So this is very similar to what is written in the EU Enforcement Directive. So to obtain a preliminary injunction, you need reasonable evidence to satisfy the court with a sufficient degree of certainty that the patent is valid and infringed. And what is also important in this case is, so there is a decision from the local division in Lisbon saying basically that preliminary injunction proceedings are only to be granted, or PIs are only to be granted under exceptional circumstances. And therefore, the applicant for a PI has to demonstrate that there was an urgency requirement, so that they really needed the alleged infringer to stop selling their product as quickly as possible. And to satisfy this urgency requirements, the court expects the applicant for the preliminary injunction to act as diligent as possible. So to not delay the proceedings and to bring the case before the court as quickly as possible. And this was a tricky part, or a tricky point in our case, because so we obtained this material from the Dutch market, but of course then to demonstrate that this is really what is protected in the patent, that this is identical to the strain that is patented. I mean, this of course takes experimentation, which takes a lot of time. So the main challenge here was, so how can we build a strong case? How can we prove infringement while still meeting the urgency requirements that are defined by the UPC, that you are expected to bring the case in front of the court as quickly as possible, because, as I said, generating the necessary evidence just takes a lot of time. And this is what I would like to talk about now. So first of all, the question that came up is, what kind of evidence do we even need to prove infringement of the patent? So here's again the claim. So it's directed to the mushroom strain BR06 as deposited at this ATCC institution. So the first question was, what kind of evidence do we need to show that the two strains, the one obtained on the market and the deposited strain, are indeed identical? So one option would be genetic evidence. So, but also there are different options. There are these fragment analysis, which basically just delivers snapshots of the genome. So it gives you some indication that the strains can be identical, but it doesn't give you the whole picture. And then there is the gold standard, which would be whole genome sequencing, which is sequencing the entire genome of the two strains, comparing them to each other, and then deciding if the two strains are identical or not. And then a second option would also be morphological evidence. So just looking at the two mushrooms, telling, are they identical? Can they be identical or not? And then the question, of course, appears, like, which features are we looking at? Because a mushroom is a complex entity. So what are the relevant features to compare two mushroom strains? And so these questions were discussed at the beginning of the hearing. So at the beginning of the hearing, we discussed claim construction. We discussed how is the claim to be understood, and how can identity of the two strains be demonstrated. And here, basically all sides, so both applicant and defendant and also the court were of the opinion that it would be sufficient to show identicality of the two strains if it can be shown that they are genetically identical. So if they are, cannot be distinguished on a genetic level, it was, everyone was agreed that then these two mushroom strains should be considered identical. But of course, there was then some discussions about when are two strains to be considered identical. And here the defendant argued that the patent can only be considered infringed if the two strains, so the one deposited and the one obtained from the Dutch market, can be shown to be 100% identical. And this leads us to another challenge, which is that even with the gold standard method, so the whole genome sequencing, it is never possible to show 100% sequence identity of two strains, even if you would take the same strain, sequence it twice and compare the data, you would never get 100% because there is always some small percentage of technical error that prevents you from getting to this 100%. So this is here one figure from one of our submissions where we compared a whole array of mushroom strains with each other. So here you can see that we see 100%, but this is only if we compare the same data set with each other. So one and the same data set, just compare it, and then it's of course expected that the identity is 100% because you compare the same thing with each other. While if we take like biological replicates of the same strain here, for example, this heirloom strain, you can see that the identity is always close to 100%, but it never reaches 100%. And this is due to this technical error that is always, or that cannot be avoided even with the most state-of-the-art methods. So this then raises the question, if you cannot technically demonstrate 100% identicality, like what standard can be applied to prove that a strain that is on the market infringes the deposited strain? And this was discussed in detail then at the hearing. And we were arguing basically that a strain should be considered identical to a deposited strain if it would be indistinguishable on a genetic level from a biological replicate of the deposited strain. So if you take the deposited strain, you sequence it twice, you compare the sequences, and then you get a certain degree of sequence identity. In this case, this was 99.88%. And then if you sequence the strain in question and you get the same level of similarity, so also this 99.88%, then the two strains can be considered to be genetically identical. And so the court followed our argumentation. So they said, however, genetic identity can be assumed to exist also in the case the sequencing results show a similarity of 99.88% or above. And here the important part is that to show a similarity between the two strains, it is required that the similarity falls within the threshold established for identical samples. So you take two identical samples, you compare them, and if then the strain in question is indistinguishable from these biological replicates of the deposited strain, then they can be considered to be genetically identical. And so this was here then found in the reasoning. In view of this, the court is sufficiently certain that based on the evidence filed by the applicant Cayenne, so the strain from the market, and Heirloom BR06, so the deposited strain, can be considered so genetically similar that this is indistinguishable from genetic identity within the applicable limits of experimental error. So this was the standard that the court set. And so the key message is, you don't need 100% that you cannot even obtain technically. It is sufficient to show that the strain in question cannot be distinguished from the deposited strain with the most state-of-the-art methods. Then the question was also morphological data, so just the appearance of the mushroom. Was this data considered? Because both parties filed morphological data. So the defendant, they listed a whole list of features that they considered to be different between the deposited strain and the strain from the Dutch market. However, these were features that were not mentioned in the patent. And on our side, we also did morphological tests because we knew that they would raise this defense. We knew that from the Polish proceedings. So in anticipation, we did some morphological tests, but we focused on features of the mushrooms that are described in the patent. So which is the size and the color of the cap of the mushroom, the productivity of the mushroom, and the compatibility of the mushrooms. And so we looked at these key features. We compared these two key features between the two mushroom strains in question. However, the court said that they don't consider these data relevant. So for them, the genetic data is relevant. But what was good for us, so they said, so the court is sufficiently convinced by the Royce report, which is the expert report that we provided, that Cayenne, so the strain in question, has the same characteristics as described in the patent, as important and attributed there to strain BR06. So they said they don't really consider morphological data, but if they were, then they found the data that is based on the features that are explained in the patent to be more convincing than just features that don't find any mention in the patent. So the court basically followed that they considered the patent to be infringed, that the strain that was obtained from the Dutch market would infringe or would be genetically identical to the deposited BR06 strain. So then the question was, of course, still, do we still meet these urgency requirements set out by the UPC? And as I mentioned in the beginning, so obtaining this evidence that was necessary to prove infringement took time. So as I said, we obtained the mushroom samples in the Netherlands in late July 2023. Then we had to obtain the deposited strains. This also takes a couple of months. So they were deposited in the US and get all the paperwork into place and obtain the samples really takes multiple weeks. Then the strains have to be grown in the lab. DNA has to be extracted. So all the methods have to be set up. So this also takes considerable amount of time. So the genetic analysis of the samples was then conducted finally in December 2023 or January 2024 when we had the sufficient material. Then we sent the genetic data to an expert who did the analysis of the data. So an independent expert who analyzed the data that we obtained. We also started then these morphological tests in January 24 because we only learned in November 23 that they would raise these morphological arguments. So before that, we did not consider these morphological tests relevant, but as we then know that they would raise this defense, we also had to find a lab to carry out the morphological tests. We had to provide them with the materials, which then again took time until January 24. And in the meantime, there were also discussions to settle the case. So, but these failed in December 2023. And then, we finally had all the data, the genetic data, the morphological data ready in late March, April 2024. And we filed our application for provisional measures in May 3, 2024. So the question is, are these 9 months or around 9 months that it took from obtaining the sample to filing the action, are these considered too long by the court? Do they consider all the experiments that we did necessary to apply for a preliminary injunction? So there was a lot of discussion about the urgency requirements of the UPC. And here the court, luckily, they followed us. So they said, first of all, for an unreasonable delay to be present, the applicant has to behave in such a negligent and hesitant manner in requesting provisional measures after it became aware of the infringement of the patent. So they said you really have to act negligently and hesitant, and they found that this was not the case. So here in this case, because we could demonstrate that we continuously worked on the case. We could argue why all the experiments that we did to prove infringement were necessary, also why the morphological experiments were necessary, because they raised the same arguments before in the Polish proceedings. So they concluded as Amisel started proceedings as soon as it had gathered the reasonable evidence, there is no unreasonable delay. So just here, this is a quick, to give you a short overview of how quickly these PI proceedings can be at the UPC. So as I mentioned, we filed our application on May 3, 2024. Then there was a bit of back and forth between the parties in the coming weeks. So the court then already set the date of the hearing for July 9. Then there was, before the hearing, there was a bit back and forth between the parties. But then, yeah, the hearing took place on July 9, 2024, and we got the decision. So the court granted the PI in July 31, 2024. So the whole process is very efficient. So we got in less than, or in around 2 months, we got from, or 3 months from filing the application to the granted preliminary injunction. So the key takeaways for the case is that a PI is still an option, even if you need to obtain experimental evidence that requires extensive experimental testing and therefore takes a lot of time. However, if you are in a situation where it really takes time to gather the necessary evidence to prove infringement, it is important to really do only the tests that are necessary to prove infringement and argue why these tests were required. So don't do any tests that do not seem absolutely important, absolutely necessary to prove infringement. And what is also important is to demonstrate to the court or prove to the court all the communication that took place between the labs and the experts, and also any attempts to settle the case, so that you can really prove to the court that you never took any breaks. So you were always constantly working on the case and trying to bring the case forward and not unnecessarily delay the case. So regarding the standard for proving infringement of a deposited strain, so the whole genome sequencing is still the gold standard, even if it's not perfect, even if it cannot provide 100% sequence identity. However, so the standard that is to be applied there is then that, so if the strain in question, the allegedly infringing strain, is indistinguishable from biological replicates of the deposited strain, then the two strains can be considered identical, even if it is not possible to show these theoretical 100% sequence identity. So in the end, I would like to briefly mention the people that were involved in this case. So the case was led by Rick Lumbers from the Brinkhoff side of Vossius Brinkhoff, together with Dan de Lange and Jasmine de Groot. So these are all from the Amsterdam Brinkhoff side, and from the Swiss Vossius side, Philip Marchand and me were involved in this case. And that's from my side, and thank you very much for your attention.
Thank you very much, Tilman. This was really insightful, also a perfect mix of procedural and technical questions. So there was something for everyone. We have one question from the audience saying, thank you for the presentation. If whole genome sequencing is the gold standard, do you think it will become a requirement in future UPC cases?
This is hard to tell. I wouldn't say it's a requirement. It would become a requirement. So for a PI proceedings, I mean, the standard, as I mentioned in the beginning, is the court has to be sufficiently certain that the patent is valid and infringed. So we also ask ourselves, would it be sufficient to do, for example, the fragment analysis, to just look at snapshots of the genome, and if all these snapshots are identical, then the two strains can be considered to be identical. So I would say these fragment analysis might be sufficient, but it would be then a bit more uncertainty involved. So I think if possible, you should always go for whole genome sequencing. And I think it's not that expensive, not that complicated anymore. There are commercial service providers that can sequence genomes in a few days. So I think I would always go for it because it's just easily available nowadays, which was different 15, 20 years ago when the patent was filed. But I wouldn't say to get a PI, it is absolutely necessary, but I would recommend it because, yeah, it's not that difficult anymore to do it.
Yeah, agree. Thank you. Maybe also one last question from me. You said that the UPC considered this threshold of similarity of 99.88% and above. Was this, I mean, did you have, how did the UPC come to this threshold? Was this something you showed because you showed the technical error is usually this, or?
Yeah, this is really method specific and sample specific. So this is not a threshold that can be applied generally. So this is what we obtained with our method. I mean, also these genetic whole genome sequencing, like the data analysis, can really impact the outcome. So we said with our method that we are using, if we sequence the deposited strain twice, and we compare the two data sets that are obtained, then what we see is this 99.88%. And then if we again sequence the strain in question and compare it to both of the replicates, and we also see something like 99.88%, then the two strains cannot be distinguished. So they are considered genetically identical. But yeah, so the specific value is really case specific and method specific. So this is nothing to be applied generally. So the value is usually, yeah, the identicality between two biological replicates of the deposited strain. And whatever you get there would be then the threshold.
Okay, thank you.
Yeah.
So yeah, I think this leads us to the end of today's satellite session, EMEA. I would like to again express my heartfelt thank you also in the name of the whole Young Members Committee of the AIPPI to our speakers of today, Vanessa, Pierre, and Tilman. Thank you very much. This has been very insightful, very current and hot topics, and very diverse. So I think we definitely all learned a lot today. Also, thank you for the wonderful questions from our participants. That was also great. So before closing the session officially, please allow me to make you aware of some upcoming AIPPI events, also with the involvement of the Young Members Summit. So this afternoon, actually, we have the last session, of this year's Young Members Summit. So from 3:30 until 5:30 Central European Time, the session will be held for the Americas. So I'm sure this will be interesting, and also for the European participants, the time is feasible, I think. And then already in a week, so on 17th of July, the webinar of the AIPPI CP series, also with the involvement of the young members, AIPPI Young Members Group, on AI and copyright case law, Where Are We Now, will take place. So I think this will be a perfect continuation of Pierre's presentation of today. And then, of course, also the 2025 AIPPI World Congress is actually just around the corner. As you might know, it takes place in Yokohama, Japan. Registration is now open until 31st of August. And also, of course, the Young Members Group is also very active in the course of this Congress. And we would specifically like to let you know that the Young AIPPI Forum is on 15th September at 4:30 in Japan. So we all look forward, or the Young Member Committee looks forward to seeing you all there. This leaves nothing open, and I would like to thank everyone again and officially close the session. Have a wonderful day, everyone.
Thank you, Luisa. Bye, everyone.
Thank you, everyone.
Thank you. Bye, everyone.